All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Please be seated. We'll hear argument in two cases this morning. First is 21-994, LG Chem America versus Morgan from Brazoria County and the First Court of Appeals District. Justice Young is not participating. Second case is 2230, Boozer versus Fisher from Tarrant County and the Second Court of Appeals District. The court has allotted 20 minutes per side in each of the cases, and we'll take a brief recess between them. The arguments are being webcast this morning and will be available in the court's archives later. We're ready for argument in 21-994.
May it please the court. Mr. Higgins will present argument for the petitioner. Petitioners have reserved 5 minutes for rebuttal.
May it please the court. Specific personal jurisdiction requires that the defendant's purposeful contacts with the state give rise or relate or give rise to the plaintiff's claim. Specific personal jurisdiction does not exist in this case. The reason is that the contacts that the plaintiffs have identified are not sufficiently related to Mr. Morgan's claim that he was injured by an 18650 cell he acquired and used as a standalone battery. And I want to talk about two things today: why personal jurisdiction does not arise, and I want to touch on briefly the petitioner's second issue concerning the Court of Appeals' failure to properly apply the burden shifting analysis that this court set forth in Kelly versus General Interior.
Could I ask you, do you concede that you would be subject to personal jurisdiction if, let's say, the injury was caused by a power tool that had been sold by Black & Decker?
I think I can't really speak to a case that in the abstract, but I think the consideration, if there was a dispute as to personal jurisdiction, the consideration would be different. The question would be what the stream of commerce plus factors and not relatedness. We would not be here arguing about relatedness in that situation. This is a relatedness case. And
you sell a lot of batteries to Stanley Black & Decker, right?
That's what the plaintiffs claim, and that's not disputed for purposes of this record.
So why wouldn't the stream of commerce plus factors be met in the case that Justice Lehrman put to you?
Well, you would have to look, and again, we're not here about that question.
Well, but we have to look at all kinds
Sure.
of things.
Absolutely. One would have to look at the steps that the product took from LG Chem in South Korea to reach the state of Texas and to reach the manufacturers in Texas. And I could foresee circumstances where there would not be sufficient plus factors. But again, that is a case that's not a record before the court, and that is not a case where we are disputing, for purposes of today, that question. And I think the important point here is that 18650s are not consumer products. They are industrial components. They are incorporated into battery packs. The California Court of Appeal in the Lawhon decision, which is at tab D of the bench book, I think describes it best. LG manufactured 18650 batteries for use in specific applications, such as power tools, where the cells are encased in a battery pack with protective circuitry. The batteries are sold as industrial component products. And this case is not about an industrial component
Before you
product.
get too far into relatedness, do you concede that both entities, the Korean entity and the American entity, shipped the 18650 into Texas?
We do not dispute that. We do not dispute that. Under LG Chem's intended chain of distribution, a naked 18650 that was outside a battery pack without protective wiring should never have reached the hands or the pockets of Mr. Morgan. And the reason is that LG Chem did not serve a market for consumer 18650 lithium-ion batteries.
So what do the cases tell us about how you segment the market for purposes of personal jurisdiction analysis? I mean, you would think that there would be a clear answer by this point in the game on when component part manufacturers are subject to personal jurisdiction or not.
Well, there are cases, and those cases are inapplicable. I don't believe this is a case of market segmentation. This is a case of different markets.
Well, you're saying you sell them in wholesale to other users and you don't sell them for retail. So what I'm asking is, what do the cases tell us about how outside of this particular fact pattern, which I know has come up in a lot of different courts, but outside of this type of case where LG is a party, what do the cases tell us?
The cases tell us that there must be, and Ford tells us this, that there must be clear notice that the defendant's contacts with the state will give rise to, or will result in the claims, the claims in that state. That's what the cases teach us. And I think Ford is probably the best teacher on that point.
And do they say that you have to anticipate who the claimant will be, or that you have to anticipate the type of claim?
Well, you need to anticipate that the activity will result in the claim. And
The
I would say
activity
that,
being selling the batteries in the state.
well, we were selling industrial components into the state.
Isn't that really what Ford dealt with, and doesn't that go against your position here?
No, I don't believe it does, because Ford is starkly different from this case. The California Court of Appeal referred to a chasm between the facts of these cases and the facts of Ford. Ford, and I think 2 weeks ago in Yamashita, Judge O'Scanlan of the Ninth Circuit had said that Ford did not address this case, and Judge O'Scanlan applied the principles set forth in Ford to reach the correct conclusion that specific personal jurisdiction does not arise in this case.
Isn't this, though, analogous to the component parts that was dealt with in Ford?
Well, Ford was subject to jurisdiction because it served markets for Explorers and Crown Victorias in the forum states. Ford served those markets. And what Ford was arguing was not LG Chem's argument. Ford was arguing, we serve the markets, but King's X, we are not subject to jurisdiction based on the happenstance that we sold, that we did not first sell the Explorer and Crown Victoria that was involved in the accident into those states. And the Supreme Court rejected that argument.
Because Ford was selling component parts to that state, right?
No, Ford was serving a market for the very vehicles that were involved in the injury, for Explorers and Crown Victorias. It was Ford's service of the market. The court did note all the steps that Ford took, the truckload of steps that Ford took to foster that market, and one of those happened to be the supplying replacement component parts that would induce people in the forum states to purchase the vehicles secondhand and to keep them well past the warranty date. But what the Supreme Court said is Ford had clear notice, and the fact that Ford did not sell the vehicles into Montana and Minnesota did not change that it knew that its assiduous cultivation of the market for Explorers and Crown Victorias would result in lawsuits when Explorers and Crown Victorias injured people in Montana, in Minnesota.
Mr. Morgan's counsel says that LG is really asking the court to engraft a subjective intent element onto personal jurisdiction that we have never really recognized. We've always just evaluated the contacts themselves, and if the contacts themselves were sufficient, we didn't really determine, the purposefulness of the availment in connection with personal jurisdiction. And what's your response to that, especially given that in a strict products liability claim, there really isn't even an intent requirement?
I would respond that with all due respect to the state of Texas, that makes the argument. That argument does not make sense to me, because intent is always an element of purposeful contacts. You cannot have purposeful contacts without intent. And I think the state of Texas uses the analogy argues that if somebody drove a car across Texas and got into a car accident, they could not argue that we are not subject to jurisdiction because we did not enter Texas for the purpose of causing a car accident. Well, the relevant purposeful act is driving the car into Texas. And in a products case like this, the relevant purposeful act is serving the market, serving the consumer market, and LG Chem did not serve the consumer market.
But doesn't that require an examination of LG's purposes in selling the batteries in Texas? That we have to ask, did you intend to sell only wholesale? Did you intend to sell eventually to consumers through authorized products as opposed to unauthorized products? And so that seems like an inquiry into LG's purposes in availing itself of the forum.
I don't believe that is quite the inquiry here, because it is undisputed, the evidence shows, and it is undisputed that LG Chem never served a consumer market for these particular products. This is not a matter of wholesale, this is not a matter of resale. This is a matter of serving a market of manufacturers seeking industrial components.
So let's say that's true. Let's say that you're correct on the subjective intent aspect, which I'm not saying that the court would rule that way, but let's say if they did, then you sell this battery to a wholesaler just for the intent that, that's the market, is the wholesaler. But you know that it's got to go someplace else because the battery isn't doing any good just sitting there with a wholesaler. So it's going to have to be sold to somebody who's going to sell a product that's going to use that. But that person, that seller, is not in the position to even be able to make this particular product safe. So how in the world are you going to have the duty to keep something safe from the public fulfilled if the person who is selling it, knowing that it will be sold to a third party to sell it to the public, is not able to be found liable?
Because any intermediaries that LG Chem made the sales to are industrial suppliers. They're either battery packers or industrial suppliers who supply the 18650 to manufacturers.
So they're supposed to have experts and scientists who look at these batteries and make sure that they're manufactured properly and that they're safe?
Well, they are sold for purchase by manufacturers, and the manufacturers have a whole range of applications for these cells. All of the cells are put in the battery packs, but 18650s power products that run the gamut from power drills to electric sedans, and they're equipped with protective wiring. And from that gamut of products, one can see that there are so many different applications. It's up to the manufacturer. It's up to the manufacturer to determine the number, to determine the wiring. This is an industrial market.
And that might be a great defense on the merits of the product liability claim, but what I'm wondering in listening to you explain your proposed rule is if we adopt that, will there ever be personal jurisdiction over a component part manufacturer in Texas?
Yes, there would be. And the
When?
reason is, well, and the reason for that is that a component part manufacturer may be subject to jurisdiction based on the stream of commerce when the component part manufacturer is sued for supplying component parts. And that's not and the reason is that the component part manufacturer, again, depending on the plus factors, the component part manufacturer has made an effort to serve that market in the state, depending on the plus factors.
What if Black & Decker had sold some 18650s to a power tool manufacturer, but it's a knockoff, right? And so we're still talking about an industrial product, but nevertheless, there's been a diversion. Jurisdiction or no?
That would be market segmentation in that case. You can't, I agree, you can't segment the market. So depending on the plus factors, there is jurisdiction, depending on the plus factors.
And so your limiting principle then is just that we're talking about the industrial market. So diverting to consumer, that's the limiting principle, and you would say that is off limits, but you would not challenge jurisdiction if the diversion had occurred but not gone beyond the component part manufacturer market. Is that the limiting principle?
Well, it's not diversion, it's the market that LG Chem intends to serve. And here, LG Chem intends to serve a market for these component parts. It's not diversion, it's not serving the market. It's not serving the consumer market for standalone lithium-ion batteries. And as a result, LG Chem does not take on the reciprocal obligations that come with that. I think the plaintiff makes the point in their brief, make a statement in the brief that illustrates the point. They say, well, LG Chem had the obligation to make 18650s safe for consumers in Texas. Well, LG Chem was not selling 18650s as standalone batteries. LG Chem was not serving that market. And so LG Chem did not undertake the obligation or the promise, the reciprocal obligation to equip 18650s with protective wiring, which would be redundant and ridiculous because the manufacturer of the end product would need to remove that protective wiring.
Your time has expired. Mr. Higgins, are there any other questions?
There are no. If there are, I will sit down and I will yield my time back.
Thank you.
Thank you.
We'll hear from the respondent.
May it please the court. Mr. Sawney will present for the respondent. Mr. Stone will present for the amicus. Mr. Sawney will open with the first 13 minutes.
Good morning, Mr. Chief Justice, and may it please the court. I want to turn directly to the first hypothetical posed to LG's counsel, and that's that if the battery had exploded in a Black & Decker power tool, there would undisputably be jurisdiction, and LG has itself conceded that in other litigation. We've included in the record the transcript from the Turner case in which LG's counsel conceded there would be jurisdiction, and that makes sense because there's no dispute that LG ships tens of thousands of 18650 batteries to Texas companies, both directly and indirectly through its distributor, LG America. And given the size of these batteries, that's something like millions of batteries over a period of year. But I think another hypothetical even more clearly illustrates the flaws in LG's position, and that's if if a Black & Decker worker at the Black & Decker plant outside of Dallas was picking up one of these batteries, taking it to the assembly line, and it exploded in that worker's hand or in that worker's pocket, there would also unquestionably be jurisdiction because there, LG's purposeful contacts with Texas, shipping the batteries to Texas, would be actually the direct cause of the injury, right? So there it would actually satisfy even Ford the company's test in the Ford decision before the U.S. Supreme Court. But the point to note is that the claims of this factory worker and the operative facts surrounding those claims would be indistinguishable from Mr. Morgan's claims here. Both are product liability cases. Both are injuries caused by, an allegedly dangerous battery. And so there's nothing different about those two cases. So if LG concedes that it would have jurisdiction, there would be jurisdiction in Texas courts in the first situation, there's no basis to distinguish it from the second situation, except that LG did not intend for Mr. Morgan to get the battery, right? Or that LG did not directly give the battery to Mr. Morgan. But who gives the battery to Mr. Morgan is irrelevant under the Ford decision, right? So the Ford decision puts out a clear rule for the vast majority of product liability cases. When a company serves a market in a state for a product, and that very product injures a state's resident in the state, then due process permits jurisdiction. And so really, LG's specific market theory comes down, as you mentioned, Justice Bland, to a question of intent. The only question is, the only distinction between the case in which there is jurisdiction and where there isn't jurisdiction is whether LG intended or anticipated that the particular plaintiff would use the battery.
If there was objective evidence that LG walled off its product and said, not for consumer use, if we sell this battery to you, you're not to resell it to anyone else outside of the authorized purposes of our agreement, would that matter, or are they still subject to jurisdiction?
No, Your Honor, it wouldn't matter for jurisdictional purposes, and that's because, again, under Ford's rule, it's the same product that injured the plaintiff. Now, I think this goes to Justice Busby's question earlier. That would be a very strong defense on the merits. And I think it's important, this court has made clear in Michiana and other cases that courts should not equate the jurisdictional inquiry with the merits inquiry. But we should remember that Texas courts can have jurisdiction over a type of case or claim, and in every case, they could rule, they could dismiss the claim. So in a situation in which a company has structured its conduct such that it's plainly unforeseeable that a consumer would use that product, I think in each case, the company would likely win on the merits. Now, of course, this is not such a case. Batteries of all mass products are kind of the most obviously interchangeable and versatile. And like the whole point of producing a battery like the 18650 lithium-ion battery is to power a whole range of particularly consumer products, power tools, laptops, vacuums, and e-cigarette devices. And so it's particularly given the facts in this case, I think it's hard for LG to argue both on jurisdiction and on the merits that it's not foreseeable that its battery, which is intended to power consumer devices, would power some consumer device, even if it's a different device than it intended.
So if you had to point us to one or two cases that you say are the best view about how jurisdiction over component part manufacturers or rejecting what you view as this market segmentation that they're trying to do, what would you say those cases are?
Yes, Your Honor. So in the context of, ironically or not ironically, post-Ford, this issue has been mostly litigated with these particular facts, right? So you have the Mississippi Supreme Court's decision in Dilworth. You have the Georgia Intermediate Court of Appeals decision in Lemmerman. Those, of course, involve exploding batteries. Then on our brief on the merits, we have a footnote citing to a range of cases from all over the country, all of which predate Ford, but they show that courts routinely exercise jurisdiction over component product manufacturers. We have a Washington Supreme Court case. There's a very kind of seminal Illinois Supreme Court case from more than 50 years ago. And I think your questions to my friend on the other side kind of make clear the kind of drastic consequences of LG's theory. So LG here is trying to just make a distinction between industrial and consumer markets. But if this court recognizes that distinction, there's no question that LG or another company would come back and try to draw that distinction thinner and thinner, right? LG could argue that it could only be subject to jurisdiction when it's a Black & Decker power tool that explodes in the state, not another company, say a Bosch power tool that was actually manufactured in another state, even though it's still the same LG battery at issue. You could also imagine a situation in which LG could argue, we have only sold to an industrial kind of manufacturer in East Texas, and we had no idea that some of these products would end up in West Texas because the market we sought to target was simply in East Texas, a more populated area of the state. And you would have to then be drawing these lines in each case, and not you, the trial court would have to be drawing these lines at the jurisdictional stage. And so I think Ford and this court in Luciano created a simple rule, and Justice Kennedy in the Nicastro plurality made clear that jurisdictional rules should be straightforward and clear, both for courts and litigants. And the rule is that in the majority of product liability cases involving mass-produced product, right, not custom products or unique products, but mass-produced products like batteries, you have this simple rule. That's when the company serves a market for the product in the state, and that very product injures a resident of that state in the state, there's jurisdiction.
Closer to home, there has been a case come out of the Southern District, authored by Judge Brown, the Etheridge case that seems to adopt the petitioner's market segmentation theory. I was wondering, that's now on appeal to the Fifth Circuit. Is there a way to distinguish that case?
Well, first, yes, it is on appeal to the Fifth Circuit, and I think the Fifth Circuit will kind of weigh in on what it thinks there. From what I remember, the record is thinner in that case, so there is not the same evidence that we've submitted in this case of, thousands of pages of customs data, which shows specifically that LG shipped 18650 batteries to Texas customers. And I point the court to especially the most clear example of this is at the record at page 564 to 65, which shows that LG shipped more than 20,000 pounds of 18650 batteries, specifically to Green Battery Technologies, which is or was an Austin-based company at the time. And so I think that's a basis on which this court could distinguish it. Similarly, that's the case in the Yamashita decision, the Ninth Circuit decision. There was no evidence in that case or allegations that the company had shipped 18650 batteries to Hawaii. But I think, respectfully, I think the Etheridge decision and the Yamashita decision misread Ford, and their legal analysis is also flawed. And so this court obviously is not bound by those decisions in any way, and I think should apply Ford and Luciano as they are written.
Is it your position that there's no line to be drawn at all for jurisdictional purposes based on an unintended or unanticipated use of a product that was intentionally shipped into a state? Or is it your position there is a line to be drawn, appropriate line to be drawn, we're just not there in this case?
Yeah, Your Honor, I don't think I can, there are these difficult kind of edge cases that it may be in which, there would be some other, I can't really think of one right now. I think in this case, there's really no question.
You're not aware of any actual case
Yeah.
where a line was drawn on that basis that you agree was an appropriate
Yes,
line?
I agree. Yeah,
And
that's
you can't
correct.
think of a hypothetical where a line would ever be appropriate on that basis?
I cannot, except I'm sure someone can construct a very fanciful hypothetical, but I think in any case involving a mass product, I think the unintended use would really go to the merits of the product liability action. I guess, there is always the third prong of the jurisdictional inquiry, which here, of course, LG has conceded that exercising jurisdiction would not offend traditional notions of fair play and substantial justice. I think it's possible, perhaps in a very fanciful hypothetical, or in a situation like Asahi itself, where it's wholly international in some way, that prong of the inquiry could serve as a backstop. But I think, in the vast, overwhelming majority of cases, unanticipated use is a merits defense, not a defense on jurisdiction. So unless there are any further questions, I rest on the briefs.
Any other questions? Thank you, Mr. Sawney.
Thank you very much.
General, we'll hear from you.
May it please the court, I'd like to pick up with your last question, Justice Wood, who I think ties into a question from Justice Bland earlier about what would happen if there were a case here where, for example, it's still intent-based, is that LG Chem and LG Chem America didn't intend for ultimately to serve a given segment of the market, but there were objective business contexts that affect. For example, maybe a contractual restriction on alienation beyond very specific entities or something along those lines. I think at least then this case wouldn't fall so squarely in the rule this court articulated in Michiana and Moncrief Oil, where an individual's subjective intent is irrelevant to the personal jurisdiction analysis. I think maybe in an extreme case, Justice Boyd, for example, if someone was bringing a consumer liability action against Ford because they used their truck as a boat, it might be something that would be so extraordinary that it defeats that relatedness component. I think it required something maybe that extreme. But remember, from Ford itself and from Luciano, when you have the identity of products between where the additional conduct brought that product into Texas, has been marketed, advertised, and then the actual claim itself is premised on that same product, spray foam, for example, Luciano, or a Ford Crown Victoria, it's either always or virtually always going to be sufficient to establish both, again, with the additional conduct for the purposeful availment piece, and then the connection between those through that identity of products, you're going to have that relatedness component satisfied. As a practical matter, at least, because when it's the same component and you've got the same component or product, and you have the same that advertising, the minimum but-for causation is almost always going to be present. So I think that's where this would be a little bit harder of a case if there were some form of objective business contact. But here, to take a step back, the exclusive reason why LG Chem and LG Chem America argue that purposeful jurisdiction is inappropriate is their subjective expectations as to how their components, after resale, that they, by admission, have advertised, marketed, distributed in Texas, are being used by someone they didn't expect. That, whatever its merits as an argument, has nothing at all to do with jurisdiction, which is fundamentally a question of the propriety of the exercise of state power. And so taking a step back from the various doctrinal formulations, the key question stated by this court, stated in Castro, is essentially, has a given defendant used the state, come into the state, sought the protection of the state's laws and the forum state as a market. And just to be clear, Justice Busby, I think this explains the question you had earlier about what the cases teach about markets. The cases always say that it's the forum state that's the relevant unit. It's not some subcomponent economically of the forum state, but whether or not defendants have availed themselves of the forum state itself. And you can see that in the Castro, Ford, Luciano. It's essentially uniform. Whether or not LG Chem and LG Chem America have availed themselves of Texas, that much is clear. They've admitted as much on the additional conduct side, marketing, advertising, distribution, all sufficient additional conduct. Since Asahi and since then, TVS Teca confirms, for example, that advertising alone is sufficient additional conduct to justify purposeful availment to Texas. And so once you have that purposeful availment and an identity of product between the product that's essentially the subject of the purposeful availment and the actual claims brought here, which is to say an 18650 LG Chem battery exploded, that's sufficient. It's enough for personal jurisdiction, and subjective intent as pleaded or perhaps even proven is simply beyond the point. I mean, I think that the Petitioner's Counsel was very candid about their position about intent in response to your question, Justice Bland, where he said something along the lines of intent is always a component of purposeful availment. The problem, of course, is this court has held that it's never a component of purposeful availment, at least twice. Has been very clear that the court said, and I'm quoting, that a defendant's subjective intent does not negate his business contacts. And to be even more direct about it, in Moncrief, the court said what the parties thought, said, or intended is generally irrelevant to their business contacts. For good reason. If this is a doctrine about power and about reliance about the state of Texas and whether or not Texas courts have the power to adjudicate a claim, of course the subjective expectations of a corporation that comes into Texas and advertises and sells products would have nothing to do with whether or not Texas can justly, under the Due Process Clause, exercise that power. If there are no further questions, I'm happy to see the balance of my time.
Any other questions? Thank you, General. Mr. Higgins, you have 5 minutes.
I did not reach issue 2, and I want to briefly because the state's argument points up why issue 2 is a problem. The Court of Appeals held that in part that Morgan met his burden by asserting in the response to the special appearance that LG Chem advertised in 18650s in Texas. And the court also recited other assertions, unsupported, some of them on information and belief in the response to the special appearance that are not in the pleadings. LG Chem did not have a duty to negate those.
I think the respondent's argument is that we could leave those statements in the response aside and just simply look at the record to confirm that there were sales of these batteries in Texas. Do you disagree with that?
Well, I think, number one, those customs records are irrelevant because they do not negate the evidence that LG Chem did not serve a consumer market, number one. Number two, one I believe would need to rent a basketball court to figure out what those 8.5 by 11 printouts of spreadsheets means. I can't. All we have is plaintiff's counsel's conclusory assertion that it says what the plaintiff says it says. So those are 2 points under
But once
coastal.
they've alleged that you sell these batteries in Texas, is it incumbent on you to come in and say we do not?
Well, a defendant can negate jurisdiction both factually and legally. LG Chem negated jurisdiction by establishing it does not serve a consumer market.
Well,
For-
isn't this just a legal dispute? I mean, everybody seems to agree who was sold to and how much, but it sounds like it's just a legal dispute about how that fits into the various pigeonholes that courts have constructed.
Well, I agree. The question is serving the market.
So if it's
It-
just a legal dispute, then why does it matter what was pleaded and what burden shifted to whom if there's no facts in dispute?
I would tend to agree with that, but I think what the court can also write on the question and remind lower courts and litigants that Kelly means what it says, and that Kelly means jurisdictional allegations are allegations, and allegations are made in the petition. I want to move to the point about structure and conduct. In J. McIntyre, the Supreme Court rejected the New Jersey Supreme Court's view that a defendant has a duty to take affirmative steps to avoid jurisdiction. Structure and conduct. Let's think about what LG Chem could have done, would have had to have done to avoid being sued by a consumer in Texas who managed to acquire an 18650 and use it as a battery, as a consumer individual battery. Well, really nothing short of choosing not to sell an industrial component that's vital to consumer electronics throughout the United States and throughout the world. That's the only choice LG Chem could make.
How does your theory in this case, how would it apply to, for example, the off-label use of medication by a patient in Texas? So you got a manufacturer that manufactures, a drug for birth control, but then a young woman uses it for acne and ends up sick or something. How does that apply? Your theory of the case apply to that kind of scenario?
Justice Boyd, that is a different case. And the reason is that is market segmentation, because the defendant, the drug manufacturer in that case, intends to serve a market for prescription drugs. And the plaintiff is injured by the prescription drug. So if that defendant made that argument, I would say that is a market segmentation argument. This is not a market segmentation argument. This is an argument that LG Chem did not serve a consumer market for standalone batteries. That is the key to, I believe,
Well,
the key to this case.
again, it gets to where you draw the line. And they kind of say, well, maybe there's a line out there somewhere, way over here, and you're saying, well, it's way over here. I mean, your clients certainly intended to serve the battery market, the rechargeable lithium-ion battery market in Texas.
Well, I think there is line drawing, and I think as Alito and Gorsuch said in their concurrences in Ford, there are questions left to be answered. And I think where the line is drawn in this case is well outside of it. This case is well outside the jurisdictional line. And I think one thing this case really comes back to is the happenstance and unilateral acts of third parties. Because all we have in this case is happenstance. We have 18650 sold in an industrial stream of distribution and an 18650 that happened to reach Mr. Morgan. And I think tab 2 of the bench book visually shows what we are talking about here, because it shows the intended stream of distribution, and it shows what Justice Brennan in Asahi said was an unpredictable current or eddy. And the unpredictable current or eddy is what carried the battery, the 18650, from Mr. Morgan, from LG Chem in South Korea, into Mr. Morgan's hands.
Your time has expired, Mr. Higgins. Are there any other questions? Thank you.
Thank you very much.
The case is submitted. The court will take a brief recess.
All rise.